It's the evil and the ugliness of people's hearts these days is everywhere.
This is Franky Rose's Think Tank. Here's your host, Franky Rose.
Hey guys, welcome back to the Think Tank. So we are going to watch the closing arguments for the Ashley Benefield, I guess is how it's pronounced, the Black Swan trial. So I have it set up for us. So let's see here. Alrighty. So I've been watching a little bit of this off and on. I'm not sure. How about you guys? Hello, Dandy Mexi P9. Good to see y'all. Let's do this. I agree. So I've been watching a little bit on Court TV and a lot of different a lot of people are thinking different things. A lot of people are thinking a hung jury. A lot of people are thinking acquitted. You know, the same. I did part of the poll, and it looks like they're thinking right around 55 to 60% are saying guilty. So let's see what we think.
Before we do that, all right, I want to speak directly to the observers that are in the audience. We are now about to begin closing arguments. This is when the attorneys are allowed to tell the jurors what they believe the evidence was, discuss how the law applies to this case, and explain to the jurors why they should vote one way or another. You will likely agree with one side and not the other. However, you are instructed not to behave in a manner that is distracting or in any way attempts to influence the jury using threats, intimidation, or sympathy. If the court determines that your behavior is distracting, you will be removed from the courtroom and prohibited from returning until closing arguments have been completed. This includes coming in and out of the courtroom during closing arguments if the court determines it is distracting to the jury. All right, I've got 9 copies without verdict forms. Just check. The ones I gave you should have the verdict forms, right?
Yes, sir. Yes.
Yours does? Okay, perfect.
And Judge, I will need this screen, so I don't know when you want to put it down.
All right, y'all can have a seat. All right, everybody have a seat. All right, before we get going, just to make sure one final time, did anybody discuss the case amongst yourselves? Did anybody do any research on people, places, things, or legal topics we've heard anything about? Or did anybody talk about the case with anybody outside of this jury?
No.
Members of the jury, both the state and the defendant have now rested their cases. I will now give you the initial jury instructions, after which the parties will give their closing arguments, if they wish, and then I will give you the final jury instructions before you retire to deliberate. The courtroom deputy will now hand out a copy of the jury instructions for each of you to review as I read them. The jury instructions are like your notes. You may write on them. After the trial, the deputy will collect your notes and jury instructions and return them to me to be destroyed. No one will ever read your notes. I will also add that I am confident that you can all read a lot faster than I can speak these jury instructions. Sometimes I've said to Miss Sarah that I'll take that as a challenge, but we want a good, clean record. So I am going to ask also that you stay with me as I read the jury instructions. There's also a point, like I said, where I'm going to stop, turn it over to the attorneys to do their closing arguments. So it's just be better if we all stay together. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Ashley Benefield, the defendant in this case, has been accused of the crime of murder in the second degree. Ashley Benefield is accused of murder in the second degree. Murder in the second degree includes the lesser crime of manslaughter, which is unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find Douglas Benefield was killed by Ashley Benefield, you will then consider the circumstances surrounding the killing in deciding if the killing was murder in the second degree or manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. The killing of a human being is excusable and therefore lawful under any one of the following three circumstances. 1, when the killing is committed by accident and misfortune and in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or 2, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or 3, when the killing is committed by accident and misfortune resulting from sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may nonetheless be a dangerous weapon if it was used in a manner likely to cause death or great bodily harm. Great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. I now instruct you on the circumstances that must be proved before Ashley Benefield may be found guilty of murder in the second degree or any lesser included crime. To prove the crime of murder in the second degree, the state must prove the following three elements beyond a reasonable doubt. 1, Douglas Benefield is dead. 2, the death was caused by the criminal act of Ashley Benefield. 3, there was an unlawful killing of Douglas Benefield by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of murder in the second degree, it is not necessary for the state to prove the defendant had an intent to cause death. An issue in this case is whether Ashley Benefield did not have a depraved mind without regard for human life because she acted in the heat of passion based on adequate provocation. In order to find that the defendant did not have a depraved mind without regard for human life because she acted in the heat of passion based on adequate provocation, A, there must have been a sudden event that would have suspended the exercise of judgment in an ordinary, reasonable person. And B, a reasonable person would have lost normal self-control and would have been driven by a blind and unreasoning fury. And C, there was not a reasonable amount of time for a reasonable person to cool off. And D, a reasonable person would not have cooled off before committing the act that caused death. And E, Ashley Benefield was, in fact, so provoked and did not cool off before she committed the act that caused the death of Douglas Benefield. If you have a reasonable doubt about whether the defendant had a depraved mind without regard for human life, because she acted in the heat of passion based on adequate provocation, you should not find her guilty of murder in the second degree. If you find that Ashley Benefield committed murder in the second degree, and you also find beyond a reasonable doubt that during the commission of the crime, she discharged a firearm, and in doing so caused the death of Douglas Benefield, you should find the defendant guilty of murder in the second degree with discharge of a firearm causing death. If you find that Ashley Benefield committed murder in the second degree, and you also find beyond a reasonable doubt that during the commission of the crime she discharged a firearm, you should find the defendant guilty of murder in the second degree with discharge of a firearm. If you find that Ashley Benefield committed murder in the second degree, and you also find beyond a reasonable doubt that during the commission of the crime she actually possessed a firearm, you should find the defendant guilty of murder in the second degree with actual possession of a firearm. A firearm is legally defined as any weapon which is designed to, or may readily be converted to expel a projectile by the action of an explosive. To actually possess a firearm means that the defendant A, carried a firearm on her person, or B, had a firearm within immediate physical reach with ready access with the intent to use the firearm during the commission of the crime. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which she is accused, there may be evidence that she committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser included crime indicated in the definition of murder in the second degree is manslaughter. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. 1. Douglas Benefield is dead. 2. Ashley Benefield intentionally committed an act or acts that caused the death of Douglas Benefield. Every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to do harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. If you find that Ashley Benefield committed manslaughter, and you also find beyond a reasonable doubt that during the commission of the crime she personally used a firearm, you should find her guilty of manslaughter with a firearm. A firearm is defined as any weapon which is designed to, or may readily be converted to expel a projectile by the action of an explosive. If you find that Ashley Benefield committed manslaughter, but you are not convinced beyond a reasonable doubt that she personally carried, displayed, or used a firearm, then you should find her guilty only of manslaughter. It is a defense to the crime of murder in the second degree, including manslaughter, if the actions of Ashley Benefield constituted the justifiable use of deadly force. Deadly force means force likely to cause death or great bodily harm. Great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm. Ashley Benefield does not have the burden of proving that she was justified in using deadly force. Instead, for you to find the defendant guilty, the state must prove beyond a reasonable doubt the defendant was not justified in using deadly force. The law on justifiable use of deadly force is as follows. If Ashley Benefield was in a dwelling in which she had a right to be, she had no duty to retreat and had the right to stand her ground and use force, including deadly force, if she reasonably believed that such conduct was necessary to prevent A, the imminent death or great bodily harm to herself, or B, the imminent commission of burglary, false imprisonment, or aggravated assault against herself. The elements of the forcible felony of burglary are: 1. Douglas Benefield had permission or consent to enter a structure owned by or in the possession of Ashley Benefield. 2. Douglas Benefield, after entering the structure, remained therein, A, after permission to remain had been withdrawn and with the intent to commit an offense other than burglary or trespass inside the structure, or B, to attempt to commit a forcible felony. The intent with which an act is done is an operation of the mind, and therefore is not always capable of direct and positive proof. It may be established by circumstantial evidence like any other fact in a case. Even if an unlawful remaining in a structure is proved, if the evidence does not establish that it was done with the intent to commit an offense other than burglary or trespass, then a burglary has not occurred. Structure means any building of any kind, either temporary or permanent, that has a roof over it and the enclosed space of ground and outbuildings immediately surrounding that structure. The elements for the forcible felony of false imprisonment are: 1. Douglas Benefield forcibly or by threat confined or restrained Ashley Benefield against her will. 2. Douglas Benefield had no lawful authority to do so. The elements of the forcible felony of aggravated assault are: 1. Douglas Benefield intentionally and unlawfully threatened, either by word or act, to do violence to Ashley Benefield. 2. At the time, Douglas Benefield appeared to have the ability to carry out the threat. 3. The act of Douglas Benefield created in the mind of Ashley Benefield a well-founded fear that the violence was about to take place. 4. The assault was made with a fully formed, conscious intent to commit false imprisonment upon Ashley Benefield. The elements of false imprisonment are as I have previously explained to you. If the circumstances were such as to ordinarily induce a well-founded fear in the mind of a reasonable person, then Ashley Benefield may be found to have been in fear, and actual fear on the part of Ashley Benefield need not be shown. In deciding whether Ashley Benefield was justified in the use of deadly force, you must consider the circumstances at the time the force was used. The danger need not have been actual. However, to justify the use of deadly force, the appearance of imminent danger must have been so real that the defendant actually believed the use of deadly force was necessary. Moreover, to justify the use of deadly force, a reasonably cautious and prudent person under the same circumstances would have believed the use of deadly force was necessary. If you find that Ashley Benefield, who because of prior threats or difficulties with Douglas Benefield, had reasonable grounds to believe that she was in danger of death or great bodily harm at the hands of Douglas Benefield, you may consider this fact in determining whether the actions of Ashley Benefield were those of a reasonable person. If you find that at the time of the alleged murder in the second degree, Ashley Benefield knew that Douglas Benefield had committed acts of violence, you may consider this fact in determining whether Ashley Benefield reasonably believed it was necessary for her to use deadly force. In considering the issue of self-defense, you may take into account the relative physical abilities and capacities of Ashley Benefield and Douglas Benefield. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all of the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial, and to it alone, that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, the conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's question? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and the other evidence in the case? Did the witness at some other time make a statement that is inconsistent with the testimony they gave in court? Whether the state has met its burden of proof does not depend on the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that their testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses, with one exception. The law permits an expert witness to give their opinion. However, an expert opinion is only reliable when given on a subject about which you believe them to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. The defendant in this case has become a witness. You should apply the same rules to consideration of her testimony that you apply to the testimony of all of the other witnesses. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about their testimony. You may rely upon your own conclusions about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. Now, at that point, if you would please mark that spot, that's where I'm going to ask you to stop. And I'm going to take a brief moment and explain the verdict form to you. The attorneys will now be given the opportunity to do their closing arguments if they wish. Sometimes they'll show the verdict form to you. So I want to take a minute to explain it and how it works. So, and I know you can't read it from there, and you do not have a verdict form in your packet. I have the verdict form that I'll be giving you. In the Circuit Court of the 12th Judicial Circuit in for Manatee County, Florida, State of Florida versus Ashley Benefield, case number 2020 CF 3014AX. Verdict: we, the jury, find as follows as to the defendant in this case. Check only one. When it says that, it means as to A, B, C. So as a jury, you will deliberate, and you must agree on either A, B, or C. A, the defendant is guilty of murder in the second degree as charged. B, the defendant is guilty of manslaughter, a lesser included offense. C, the defendant is not guilty. what I meant to say earlier is you must agree unanimously. That is, all of you must agree on what the verdict is. Now, if you, as a group, you debate, deliberate, and as a whole, you find either A or B, then you must go down here to this series of questions. If you find the defendant guilty of A or B above, then you must answer all of the following questions. 1, did Ashley Benefield actually carry a firearm? Yes, no. 2, did Ashley Benefield discharge a firearm? Yes, no. 3, did Ashley Benefield, as a result of discharging the firearm, cause death to Douglas Benefield? Yes, no. So say we all this blank day of July 2024 at Bradenton, Manatee County, Florida, and then it'll be signed by the foreperson, and the foreperson will print their name. And I'll talk about that when I give you the final instructions. Members of the jury, the attorneys will now present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, you should listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing argument. State.
Can I have the screen, please?
Yes. And how much did you want to reserve?
Are you going to give a warning?
Yeah. Do you want the lights down?
Yes, if we could just do the ones back there. Domestic violence is absolutely a real problem. There are many, many women around that are in horrendous situations. Women, and sometimes men, that are in situations where they're being abused and beaten horribly on a regular basis. People that feel like they cannot get out, they have no way to get out. That is not this defendant. And it never was. Now, some of those women who are victims of horrible domestic violence may be justified in a situation where they have to use self-defense to kill their abuser. Absolutely, there can be situations where that might be a valid point, but not for this defendant. This defendant used domestic violence and allegations of it to make progress on her goal. And her goal was she wanted sole custody of that child at all costs. And to understand that, I think we need to go through the background, even though this case really is about what happened in that house. What happened in that house, the last moments of Doug Benefield's life. But we need to go through the timeline to see the tenor of this relationship and to see how it unfolded. The bottom line is you have to decide at the moment that she pulled the trigger in that bedroom, was it reasonable and was it necessary? That self-defense instruction, it's called justifiable use of deadly force, is very complicated. But there are two words that are very, very important: reasonable and necessary. And those are the words that you have to evaluate everything this defendant did. So let's go through the timeline. In September 7th of 2016, this couple was married. After knowing each other 13 days and a 30-year age difference, they married each other. According to the defendant's testimony, very shortly after, there starts controlling behaviors and name calling. Then, 4/15 of 2017, Doug Benefield has a vasectomy reversal. They decided in less than a year of marriage, they wanted to have a child. This is about the time where the defendant says that there are these angry outbursts in South Carolina by Doug Benefield. And the state is not trying to say to you that Doug Benefield was an angel. The state is not trying to say that his behavior in South Carolina was appropriate. Not at all. His behavior was unacceptable at the time. But he also apologized for it. If you look at the emails, the text messages between him and Ashley, he says, I'll spend the rest of my life making this up. And he says how wrong he was and how stressed out he was. And he apologizes. But that's not the most important thing. The most important thing is what happens after that. Does any more abuse happen after that? Within days of these anger outbursts in South Carolina, there's a lavish wedding reception where everyone seems to be happy. And then within about 3 months after that, the defendant gets pregnant. In the midst of all of this, she gets pregnant. The very next month, she moves to her mother's house in Florida because she's so sick and needs someone to take care of her. That is the last moment that this defendant ever lived in the same house with Doug Benefield. Was August of 2017. Very, very important date. Within a couple of months after getting to Florida, the defendant starts this campaign of complaints against Doug Benefield, all with the idea to get sole custody over her child that she was pregnant with. So she filed for a South Carolina injunction while she's in Florida. She doesn't even live in South Carolina. She doesn't even live with the person that she's trying to get an injunction against, but finds it appropriate to get an injunction in South Carolina. It is a mutual injunction. Don't mistake that. The judge did not make any findings of fault. There was no evidence presented. No one was ever found at fault. The two parties, Doug and Ashley Benefield, agreed, fine, we just won't contact each other. That is not what we are used to probably in Florida for injunctions. Then December 2017, so that's within a month, Ashley starts the series of allegations in Florida. So she files for this injunction in South Carolina. They mutually agree, okay, we're not going to talk to each other. We're not going to be around each other. But she starts a series of complaints in Florida. She starts saying he violated the South Carolina injunction, and she claims he's poisoning me. He's poisoning me and my unborn child, and also goes back to things that he supposedly did in South Carolina when they don't even live together. So on March of 2018, she gives birth. She gives birth after Doug Benefield has a lawyer contact her because they're not really supposed to be talking to each other. The lawyer helps him write a letter where he says, I want to be a part of this child's birth. Please, I'll honor your wishes, but please let me be a part of this child's birth. Not only does she not respond, when she goes early to give birth, she doesn't tell Doug. She doesn't tell him once the baby's born. For weeks, he didn't know this child was born. Then she does not put his name on the birth certificate. Now, alleged behavior or not, she knows who the father is. Why is she not putting the father on the birth certificate? And then she gives this child her maiden name instead of her father's maiden name. or I'm sorry, her father's last name. Then 1 month later, she starts complaints to law enforcement. She says he violated the injunction in South Carolina. She files for a new injunction in Florida based on all the same things in South Carolina. This is all based on the same information that she had already spoken about in South Carolina. And when she went to law enforcement trying to get them to file criminal charges against him for violation of an injunction, law enforcement was not on her side. And you heard from Detective Gillum about the conversations that they had. And the conversations that she had with Detective Gillum are the entire crux of this case. It is her motive. It is her plan. It is what she did everything for. He said her true motives were to use the criminal system to affect her family court case, to get sole custody of her child, which is what she wanted from the very beginning. He said it was very clear that she was trying to use the criminal system in that way, and he was very uncomfortable with that. He had forwarded charges to the state attorney's office, let the state attorney's office decide, which they end up not filing, by the way. And she did not think that was good enough. She was furious. She said, and I quote, "If the judge sees him arrested, it will help me keep my baby." She wanted him arrested in family court in front of the judge and made that very, very clear. That was what was important to her. The detective said in 20 whatever years that he's been doing this job, he has never had anybody ask him to do that. Never. And she was very adamant, and they talked for 15 to 20 minutes. And she went from crying almost hysterically to aggressive and yelling at him and then screeching at the top of her lungs, all because she could not get him to go with her plan. She also said to him, "You will fucking arrest him in front of the judge, and I will make sure that you do." Then she said, "I will do anything I have to do to keep my baby, asshole." She wasn't saying, "I'm so afraid of this man. Please help me. I'm a victim of domestic violence. I need help." Not at all. She's saying, "I want to keep my baby." And she's afraid that this man, who is 30 years older than she is and a lot more established, has a lot more money, has a lot more resources, she's afraid that this man is going to get custody of her child instead of her. So after this discussion with Detective Gillum, in about September 17th of 2018, the second hearing for the injunction happens. Remember, this injunction hearing was in two parts. One was in July and one was in September. All of the same allegations. He's poisoning me, the stuff in South Carolina. Again, they're not even living together. And she fails. The judge in that case says, no injunction. And this man will have immediate visitation with his child, who, by the way, was 6 months old and he'd never met her. It wasn't for lack of trying. There may be a lot of deadbeat dads out there that don't care about seeing their children and don't want to be around. This man tried everything to be around for his child, to be there for the birth, to visit the child, to see the child. And she kept the child away from him for 6 months. And the first visitation, you heard from Stephanie Murphy, the first visitation, all of a sudden, everything's glorious again. Now, all of a sudden, the defendant wants to go with him. I'll go with you. And now we're in a stage where we're acting like we're going to get back together. Because she knew the court system was not working, and she was afraid that if she didn't buddy up to him, he was going to get this child away from her. So it begins the charade of her telling him, we're going to get back together. We're going to be a family. She played on Doug Benefield's wishes. He wanted more than anything to have a family, his family together, to have his wife that he loved and this child all together. And she kept telling him, yes, that's what we're going to do. That's what we're going to work towards. So that starts about a year of them kind of getting along, right? And then September of 2019, which is about a year later, Doug finds out she's dating someone else. He files for divorce. And a series of complaints start against Doug Benefield for now abusing the child. Which, by the way, were investigated by law enforcement, and not one of them resulted in any charges. And May 1st of 2020, the defendant, having failed in the criminal system, again, files for another injunction based on these allegations that fail in the criminal system. Do you see a pattern here? May 4th, only a few days later, after she files for another injunction, Doug files for sole custody of the child. This is Ashley Benefield's biggest fear, that this man is going to get sole custody. But she's making all of these grand allegations against him that he knows are not true. There's got to be something wrong, and it's probably not safe for this child to even be with her. So he files for full custody. And what happens? All of a sudden, she sidles up to him, and now we're getting back together. And we start to go to marriage counseling, and we go see Dr. Forrest, who referred them to Dr. Quintel. And they're going to marriage counseling about how they're going to get together. And to Doug, she's saying, yes, I want to reconcile. Let's get back together. But behind his back to the doctor, she's like, no way, no how. I'm not getting together with him. Then she goes on all these social outings with Doug and the child. Goes to the beach, goes to the movies, goes out to dinner, to lunch, swims at the pool at his apartment complex. Giving Doug all of these mixed signals. We're gonna reconcile. We're gonna get all this back together. And in the back of her mind, she knew all along. She was just waiting for an opportunity to strike. And then 6/1 of 2020, the system sends them for an evaluation with Dr. Broder. And they're like, what is going on here? Someone needs an evaluation. So they go to this evaluation with Dr. Broder, and this deception on the part of Ashley Benefield continues. She does the same thing. We're going to reconcile, we're going to get back together, and then when she's not with him, she's saying that that's not true. And then towards the end of September 2020, but before the 21st, there is a last meeting between Ashley Benefield and Dr. Broder. He said it was in his office. She was leaving. She was walking through the waiting room and going to the door, and she's upset because this is not going fast enough. I want the report. I want this to be done. We need to move to Maryland. Why do you think she's moving to Maryland? We need to move to Maryland. This is taking way too much time. And she says to him, I'll take matters into my own hands. And that was 7 days, up to 17 days before, depending on about what time it was, he gets murdered. On 9/21 of 2020, after this comment to Dr. Broder, she goes to mediation with Doug Benefield, and they end the mediation saying everyone's going to drop everything. Because at this point, Doug had filed for a divorce again. And Ashley had filed for an injunction again. So at this hearing on the 30th, those things were going to be heard, as well as a joint motion to release a report by Dr. Broder. But they go to mediation, and at the end of mediation, it's very fast because they all agreed. We're dropping everything. We're going to Maryland. So that was the plan. Ashley Benefield had no intention of dropping that injunction. Look at the text messages between her and Doug that were introduced by the state for the week before this homicide, murder happened. They're talking to each other about the fact that everything's going to be dropped. Give this attorney a call. Okay, I'll give that attorney a call. Ashley's telling him we're going to drop everything. And she knew That was not true. Her attorney testified, we were not dropping that injunction. We were ready to call witnesses. At that hearing on the 30th, we were going forward. Ashley Benefield knew that day it was over. It was going to be over. Her entire charade was going to be done. This entire get along, go along that she's trying to say was because of domestic violence. She was just trying to fake Doug out. And she knew that on the 30th, her ruse was up. Because if she goes forward with an injunction, what better way to tell someone you're not going to reconcile than trying to get another injunction? So what does this timeline tell us for what happened at the time of the shooting? Okay, it's background, yes, but also it tells you they did not live together for 3 years before the homicide. And if there was violence towards Ashley Benefield in South Carolina, that was 3 years before. And they hadn't lived together since. And is that something that justified her being in such fear of Doug Benefield that it was necessary to shoot and kill him? The answer is no. I do want to talk a little bit about domestic violence, and Mr. Ferris testified a lot about this wheel, this power and control wheel. So I want to put it up there. First of all, the overarching umbrella right here is physical and sexual violence. There is no physical violence in this case. There is no sexual violence. There's no allegations of any of this, unless you believe the defendant that the day this happened. But there was never any allegations of physical or sexual abuse. However, it's a power and control wheel. So let's go over some of these things. One of the first categories, using intimidation. So this is, did Doug Benefield use intimidation to control Ashley Benefield? They hadn't been together in 3 years. The first year they were apart, they barely even saw each other or spoke. So how exactly was he using intimidation to control her? And there's no allegations of threats during this time. The defendant testified she didn't say that there was anything going on during this time. One of the other prongs is using emotional abuse. Same answer. They weren't together. There was no allegation of emotional abuse. The defendant didn't talk about anything that was going on during this 3-year period that he was emotionally abusing her. She felt comfortable enough. She even said, I told him when he thought he was going to move in with me, I told him I didn't want to do that. She felt comfortable enough to say, no, you're not moving in with me. But yet somehow he's emotionally abusing her. Then using isolation. How can that even apply when they're not even together? He has no influence over her comings and goings, over her daily routine. And she even started a new relationship with someone else. So how is it that Doug Benefield is exercising control over her by using isolation? And then minimizing, denying, and blaming. Well, nothing had happened in 3 years. So was there even anything to minimize, deny, or blame? Nothing had happened. And there was no evidence of anything happening other than maybe some things that the defendant said happened, but did they really? For instance, Doug Benefield's peeking into my windows. My neighbor told me that Doug Benefield was peeking in my window. Okay, let's think about this. She said it was her across the street neighbor. Okay? So these houses face each other. Their backyards are behind the houses. The neighbor said, I saw somebody walking in my backyard that had a ball cap on. It was dark. I couldn't see what he looked like. And when I asked him what was going on, why was he there, he said he lived there. And somehow this translates to This person is looking into your windows across the street, and the neighbor couldn't identify who it was. And here comes Ashley with her recording. Here, let me play this. Would you recognize his voice? Does that sound like him? Okay, it was Doug. Doug was peeking in my window. Really. Then the next spoke on the wheel is using children. This man did nothing but try to see his child over and over and over. Ashley Benefield kept his child from him. So if anybody was using power and control, it was Ashley Benefield against him. And I think if you look at a lot of these folks, you're going to see a lot of behaviors on the part of the defendant that were actually using power and control instead of being a victim of power and control. Then male privilege is the next spoke. There was absolutely no evidence of male privilege. There was an email to the realtor to get a house, just as one example. And if you read that email, he says, okay, but I have to check with Ashley first. How is that male privilege? He's telling this guy he's going to talk to his wife. Using economic abuse. Again, they didn't live together. Ashley Benefield's financially independent. She has her own home. She's completely separate, has her own car. That doesn't apply. Using coercion or threats. No threats. She didn't say there were any in those 3 years. None. There were no allegations that he threatened her or hit her or did anything. He didn't make any reports or threaten to report her to Department of Children and Families. He didn't say, oh, you better do what I say or I'm going to call DCF and tell them you're a bad mom. No. That was the other way around. That's what she was doing to him. There were no allegations that he was trying to get her to drop charges. Quite to the contrary. She was not dropping any charges of anything. And Mr. Ferris talked at the end of his testimony about domestic victim mentality. So let's talk about this. One of the things in the domestic victim mentality is covering for the abuser. Like making excuses, covering for them. Did you ever hear any evidence of the defendant doing that? Never. Making excuses for the abuser, making excuses for their behavior. Not once. She was telling everybody, anybody that would listen. Not reporting abuse, same answer. She was telling anyone that would listen and a bunch of people that wouldn't listen. Dropping criminal charges. That certainly didn't happen. The domestic victim mentality, she won't stand up for herself. Never saw that with this defendant. And she won't leave the relationship or the home. She left. She left the home. She left the relationship. They were not together for 3 years. So how does this domestic violence mentality, domestic victim mentality even apply to her? It doesn't apply to her. And don't be mistaken about what applies to her and what does not. Even, like I said before, even if you think that Doug Benefield's behavior was inexcusable and abusive in South Carolina, you have to remember that we are talking about 3 years later. After all of this, time has gone by and there are no allegations of anything else in between. So I want to talk to you a little bit about the jury instructions that the judge talked to you about. I just have a few on here that I want to go through. It's got to be overwhelming, I know, when you read the packet. There's a lot of words. So I try to help break it down a little bit. So the defendant is charged with murder in the second degree. So I would recommend the way you go through this is check off the things that you don't have to argue about. If everyone agrees to one of these, just check it off. So number one, Doug Benefield is dead. That should be easy. Check it off. There's no dispute. Number two, the death was caused by a criminal act of Ashley Benefield. Check it off. She shot him. Number three, there was an unlawful killing of Doug Benefield by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. Now that's a lot of words. So what does that mean? The next slide explains what that means. An act eminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, and again, check off things, okay? So a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another. Shooting a gun, firing a gun into someone clearly qualifies. A person of ordinary judgment would know that that would kill someone. Check. Let's go to number three. That this act is of such a nature that the act itself indicates an indifference to human life. Pulling a trigger, pointing a .45 caliber firearm at someone and pulling the trigger 4 times shows an indifference to human life. So then we go back to number two. If the acts are done from ill will, hatred, spite, or evil intent. Now notice this is or. It does not have to be all of those. Ill will is a pretty low threshold. What is ill will? Devising a plan to keep this man away from his child. Is that ill will? Sure. Filing complaints against him that are unfounded and nobody ever files, fictitious complaints, that's ill will. Trying to do anything she can to keep this child to herself is ill will. Everything she did was for this goal, and everything she did was to get Doug Benefield out of the way. And unfortunately, the way she did that was by killing him to get him out of the way. That is ill will, hatred, spite, or evil intent. Now, the judge read to you that there's something called a lesser included offense. And what you may have heard, but it's in your packet, is the way you should handle a lesser included offense is such. So if you agree as a jury that the state has proven a charge beyond a reasonable doubt, you should start with the highest charge. So start with second-degree murder. And if all of the jurors agree unanimously that it's beyond a reasonable doubt that the state has proven their case and the defendant is not entitled to self-defense, then you don't even get to manslaughter. You don't have to go and then review manslaughter. You stop at the highest charge. You only get to manslaughter if you don't agree on the top charge. Then you get to the description of manslaughter. And again, check off the things that you are not arguing about. Doug Benefield is dead. Check. Ashley Benefield intentionally committed an act or acts that caused the death of Doug Benefield. Yes. There's no question as to that. Now, the state did prove this, but the state also proved the added element of ill will, hatred, spite, or evil intent. So we have proven manslaughter, but we have also proven above manslaughter. And I want to show you the verdict form, and then we'll go back. This was the verdict form that the judge showed you, just to let you see it ahead of time. And this is the heading that the judge read. We, the jury, find as follows. As to the defendant in this case, check only one. And here's A, B, and C that the judge talked to you about. Defendant is guilty of murder in the second degree as charged. Defendant is guilty of manslaughter, a lesser included offense, or defendant is not guilty. And then if you find A or B, then you have to answer all three of these questions. And then the foreperson will sign it and print their name. So the real question in this case is, Was there self-defense? Was there justifiable self-defense? And the self-defense instruction is long, and you'll have it to review in the back. However, what you will notice are two words that come up all the time in that instruction. Self-defense, justifiable use of deadly force, would be Ashley Benefield was justified in using deadly force if she reasonably believed such force was necessary to prevent imminent death or great bodily harm or a forcible felony. You're going to see those two words. And like I told you a little bit earlier, that's what you need to think of each time that you're trying to evaluate whether she used force appropriately. So let's get to the date of the offense, okay? Clearly, these two are getting along, at least according to Doug Benefield. He thought they were getting along. If you look at the text messages between the two of them, if you go by the information that you had from the witness stand that Ashley was acting nice, she was acting like they were going to try and reconcile in Maryland. They were moving together. They were using the same truck. He was coming to her house to help her move the heavy things. So they were getting along. They actually went to the mediation during this time. It was about 3 days before she killed him. They had mediation where they said they were going to drop everything, move into Maryland, everything's going to be fine. But obviously that was not Ashley Benefield's plan because she knew she wasn't going to drop the injunction. Obviously, the day of the offense, Doug Benefield had a right to be at the house. She invited him over. They had text messages back and forth. Trucker on the way. You know, he's taking a picture of the stuff in the back of his truck. And she'd let him in the gate numerous times before. So he had a right to be at the house. She clearly was not afraid because she had him over. And then her mother clearly was not afraid for her because then as soon as he gets there, she goes to the park with the daughter. So nobody's afraid at this point for Ashley Benefield's safety. And there's only one person who knows what happened in that house that is still alive. And that's Ashley Benefield. And you heard her story. And she made herself a witness just like any other witness in this trial. And you will judge her credibility and the truth of what she said just like you do any other witness. And see if it matches the evidence in this case. If you noticed, when being asked questions, she became evasive. If questions got a little too difficult or she didn't really have an answer for it, specifically on cross-examination, she would use methods to avoid answering the question. One of the methods that you saw over and over was, I don't know, I just don't know, I don't know. The other method was crying. Started crying. Did you ever see one tear come out of her eyes? Did you ever see one drop of liquid? One red eye? One swollen eye? She had a breakdown. We had to take a break, crying hysterically. Takes the stand right after that. Eyes are just fine. Makeup's just fine. That goes to her credibility. What is she trying to convey to you? The truth or her version of events? Let's look at what she did say. She said during this move that Doug bumps her on the shoulder a couple times, body check or something. She didn't really act that out very well. Who knows what that was. Doug carrying a box, rammed a box into her stomach and scratched her. But did you see those pictures? Does that scratch look like a scratch from a cardboard box? Wouldn't you expect a bruise to be there as well? You'll have the pictures in the back. So look at those pictures and see, there's no bruising. They look like cat scratches. The defendant also said when they were by the front door to the house that he grabbed her by the wrist and hit her in the head. So when I asked her, okay, what do you mean hit? Well, I don't know. Okay, was it an open hand? Was it a closed hand? What was it? I don't know. She should know if a grown man balled up his fist and punched her in the side of the head. And there would be a lot more damage than what she claimed she had. But she didn't know. He just hit her. Now, 4 people testified that they saw her after this incident, very shortly after this incident. Well, one of them was 3 days later, but the rest of them were very shortly after this incident. John Sands, the neighbor, he didn't see any swelling. He didn't see any injuries. He didn't see any disheveled clothes like there'd been a, rumble. Detective or Officer Burrell, Deputy Burrell, was the one that put her in the back of his squad car. No injuries. Didn't notice any injuries to her head or swelling to her face. Crime scene tech Dvorak took pictures. Didn't notice any injuries, any swelling to the face. 3 days later, crime scene tech Conlon takes pictures just to make sure, because bruises don't always come up right away, that she's not bruised. No bruises, no swelling, no nothing. But yet the defendant sits right here and tries to tell you that her eye was droopy and the side over here was swollen. Let's look at these pictures. These are 4 pictures that were entered into evidence. The first picture was, the defendant said, was before she even knew Doug Benefield. She thought it was before she even knew him. The second picture over to at the top, over on the right, is the night of the shooting. Down lower left is 3 days later. And then one over is about 5-6 weeks later. Does it really look like her face is swollen? She said the side. She said right here. On the right side. Or, I'm sorry, the left side. Right here. The left side of her face doesn't, it actually looks slimmer than it did in the picture taken before she even knew Doug. So let's talk about what she did when she claims that Doug grabbed, I think she said she was going for the front door. He grabbed her arm. She kind of spun around. He hits her in the head, although she didn't know if it was overhand or not. And then she said, I just wanted to get away. I just wanted to get away. Right? Here's the front door. Right? She went this way and could have gone right out the door. But she just wanted to get away. She didn't go right out the door. She turned to her right and went into this room. This room that has nothing in it except for a mattress, a broom, and a hamper, and 2 handguns. It's hard to see in this picture because of the lighting, but I just want to remind everyone, here's the mattress, here's the broom, nothing else in this room, but there's a hamper right here with a gun on it, and there's a gun in this closet right here. And that's where she runs. And this is a better picture of the hamper and where the murder weapon was. So she just wants to get away, but she runs into the very back corner of this room and grabs a firearm. Now, she claims that as she's retrieving this firearm, he slams the door open and she turns around, right? And she sees him standing there. When I asked her to get down and show me what he was doing, that was another one of those evasive times. I don't know. He was in a fighter stance. I don't know what fighters do, but I know it's a fighter stance. Okay, well, show me. What do you mean a fighter stance? I don't know, kind of like this. Okay, well, what are his hands doing? Just kind of moving around. Okay, so his hands are kind of moving around, and it didn't look a lot like a fighter stance. And then she said, I'm standing there with the gun pointed at him, and he lunges at me. He lunges at me. Let's think about this. So if she's standing in the room, she has the gun in her hand, and he just came in the door, and she's pointing the gun at him. She says he takes a fighting stance. First of all, he's right-handed. Do this yourselves when you get in the back. If someone told you to get in a fighting stance, what would you do? And determine for yourselves. Use your common sense. Which side would be bladed away? I think you'll find that your strong hand is going to be the one that's bladed away. So if he's right-handed, he's in a fighting stance, he's going to be like this. Interesting, because he's shot from this side. So he's like this. And then she says he lunges at me, right? So if he lunges at her, he's head on, straight on to her, lunging. That bullet hole would have been here and out here. Would have gone straight through him, front to back. That is not the way that bullet went. That bullet went side to side. And if he's in a fighting stance and he's right-handed, why would he have this side towards her? And Mr. Haig, the expert, the firearms expert, displayed when I said, okay, I'm going to point a gun at you. You show me where your body would have to be in order to get that trajectory. And he turned sideways. So his body in his fighting stance would have to be completely sideways. And what? He's skipping to her to lunge? I mean, how is that trajectory going to happen based on what she said? More than likely, the hands that were up was a defensive stance. He probably came into the room and said, whoa, she's got a gun, and started to turn around. He had his hands up like, whoa, what are you doing? Makes no sense to be in a fighting stance. So I want to talk a little bit about this trajectory just because there's sort of some misconception that this shot was front to back. That is just the planes with which the medical examiner uses. So it can be a little confusing. But if you look at the way this arrow is, the bullet goes in right by the right nipple and then lands right here. So it is side to side. Now, once it went in where the nipple is, did it curve a little bit to the back? Yes. That's why it's like in the back. That's why they say front to back. So it went side to side and a little bit to the back. There is no way he was facing her when she shot him. No way. Here's another angle. This is from the back. So if it went in on the side, on the right-hand side, and that red dot is where it landed in the back. And let's talk about the leg wound. It's very hard to determine exactly how this leg wound happened. And we may never know exactly how it happened. But this is the basic trajectory of it if a person were in a normal standard anatomic position. This is both medical examiners said that. This is a standard anatomical position. So in a standard anatomical position, that is the way the wound path went through his leg. So you can figure out for yourself different ways that might have happened. Now, Dr. Liu said, based on information that she got from Ashley Benefield, by the way, that it must have happened this way. That once he shot the first time, somehow he falls and his legs go way up in the air and he shot like this. Where did that bullet go? if he was shot like that? The expert testified about the two that went into the wall had not gone through a body. He said the one that hit the leg was in the room. Might have been kicked, and that's normal when you have emergency technicians in there and they're kicking things around. But the projectile was in the room. It was not in the wall. So if he's falling back this way and his legs flipping way up, and by the way, Dr. Vega said the only way your legs flip up like that is if you're falling over a rail or, falling over something and your legs come up that high. So that just does not make sense with the rest of the evidence. Now, this may not be the way it happened, but it is also another way that it could have happened. He is turned away, leg up, and that bullet could have gone in and come out his knee if his leg was bent. So you use your own judgment and decide what you think about that leg wound. What's important is this wound. This was the wound that killed him, and he was not facing her at the time. The defendant trying to say he was in a fighting stance, he lunged at me, that is just her once again trying to manipulate the system. She's trying to manipulate you to believe that this was necessary, he was coming at me, but the physical evidence does not bear that out. It does not show that he was coming at her and that she had to shoot him. And afterwards, she runs over to the neighbor's house. Not once do you hear her say, get an ambulance. I don't know if he's still alive. I had to do it, but somebody help him. Not once. Not once did you ever hear any concern that I just shot another human being, regardless of what the facts are. No. And then she sees her mother come by the car. Not once does she say, Mom, he just came at me. Like I had to shoot him. It was awful. Nope. Not a word. She goes back to her mom that night. Not a word. Really? You're not going to tell your mom exactly what happened? And then this lady, Barbara Russell, that she lives with for 9 months after the shooting, never tells her what happened. Not once. Remember, the defendant sat right there and said the defendant never punched her ever. Never choked her, never kicked her, never came at her with a knife, never came at her with a club, never came at her with a bat. And she was the only person armed in that room. Doug Benefield was not armed. He had no weapons. He was laying on the floor dying. And she goes to the neighbor and not once asks for an ambulance. And he dies, either on the way to the hospital or in the hospital. She was the only one armed, and it was not necessary. She did not have to shoot him. It was not reasonable. She did not have to shoot him. She had an agenda, and it worked for what she wanted, and she got what she wanted. Because after she killed him, what did she get? Sole custody of the child. And that's murder. Thank you.
All right, Mr. Taylor, do you need the screen?
I do not.
I'll turn that off for you. Yes, sir, when you're ready.
Thank you. Good afternoon, ladies and gentlemen. I have a bit of a cold. I tested 3 times and it's not COVID. Don't need to be concerned. I've just listened to the state's closing argument. I have to tell you, I think there's obviously some real different perceptions of what the evidence is. I think perhaps there's even been some distortions. You all have taken, we've observed, pretty careful notes. If I say something that is not reflected in your notes or is not as you recall it, I want you to trust your own recollection. But I think if you check your notes, you will find that what I represent to you is accurate. This is and has been a fundamentally flawed prosecution. And I think we can demonstrate that through the testimony of two of the state's witnesses. The first is Stephanie Murphy. And you may recall she was the attorney who was representing Douglas Benefield. In my cross-examination of Stephanie Murphy, I served up for all of us, but especially for you, the members of the jury, what the state's theory of prosecution was. And I said, so Miss Murphy, let's be clear so that there's no misunderstandings. It's your belief and the state's theory that Ashley Benefield killed her husband because the Broder report was scheduled to be released 3 days later. She said that's correct. Check your notes. Now, the state, in their opening statement, even made it dramatic. They said to you, this report by Dr. Broder was to be released on the 30th of September, but she killed him on the 27th to avoid that. If you look at the emails that had been introduced into evidence that reflect the conversations back and forth between Stephanie Murphy, Faith Brown, Miss Benefield's family court attorney at the time, and the judicial assistant for Judge Moreland, you will read in no uncertain terms, black and white, the Broder report was not set to be released on September 30th. Not only was it not set to be released on September 30th, there was not even a day for it to be released scheduled. Stephanie Murphy was attempting to have it scheduled. The JA wrote back in no uncertain terms, Judge Moreland will not hear that. The only thing being heard on September 30th is the domestic violence injunction. The other witness that I think reflects what a fundamentally flawed prosecution this is Detective Gillum. Now, you might recall that Detective Gillum, check your notes, said that the South Carolina domestic violence injunction that required no contact by either one did not go into effect until November 27th. But if you look at the written email that we introduced into evidence, where Detective Gillum is contacting Gina Torsha, Miss Murphy's assistant, Detective Gillum tells her, wait a second, he's helping them. Wait a second, this injunction, unless I'm reading this wrong, this injunction went into effect on November 3rd. The judge signed the order on November 27th, but on November 3rd, he announced it in open court and Doug was present, and so was Ashley. So unless I'm reading this wrong, I want you to be aware of that. This is Gillum trying to help them. This is the same Gillum who gives you quotes of exactly what Ashley Benefield said 2.5 years later without having one word of it written in his earlier report. The same Gillum who I asked the following questions of. Detective Gillum, do they teach you in police academy about the importance of writing reports? Sure. And is the reason why the reports are so important is because it preserves important facts about a particular incident? Yes. So how many cases do you handle, Detective Gillum, in a month? You might recall he said, oh, probably about 20. And then we multiplied that out by 2.5 years. I think we were into about 600, 700 cases. Yet he remembers the exact words she had to say, despite the fact that on the day she said it, not one word of it appears in his supplement 2.5 years earlier. Ladies and gentlemen, Detective Gillum, you might also recall, countermanded the capias, the arrest warrant that the other deputy issued for Doug Benefield when Ashley went down there and explained that Doug Benefield had mailed her this package in violation of the South Carolina restraining order. Detective Gillum said he remanded it, he reversed it, and he was going to refer it over to the state attorney's office. This was a good old boy network. They liked Doug, and they never looked back. And that's the truth of the matter. Do you not find it astounding that Detective Gillum 2.5 years later could remember such things as Ashley Benefield saying, if the judge sees you arrest him in front of her, it'll help me keep my baby. Isn't that something that you would put in a report? I think perhaps the most disturbing thing about the testimony of Stephanie Murphy and Detective Gillum is the following. Remember that common sense I told you about that you're going to be able to take with you back into the jury room, and that without offending anybody, there would probably be more than 100 years worth of it, which there is. Does anyone believe that either side calls witnesses that they don't know what they're going to say? So how do you reconcile the state calling Murphy and Gillum knowing that they're going to testify inaccurately? Read Gillum's written email about how he misrepresented his knowledge of when that South Carolina domestic violence injunction went into effect when he testified in front of you, and read the emails between Stephanie Murphy, Faith Brown, and Judge Moreland's judicial assistant. Okay, so what happens after that testimony? I want you to remember that the state's theory of prosecution up to that point is that Ashley Benefield
Judge, I'm gonna
killed Douglas Benefield to stop the release of the Broder report because she was so afraid of what was in it. And right in front of your eyes, I've never seen it before, right in front of your eyes, the state changes their theory. And the next thing you know, their theory of prosecution is she killed him because the domestic violence injunction was scheduled 3 days later. Check your notes. See if what I'm telling you is not accurate. Both theories, honestly, are ridiculous.
Objection, Judge.
Sustained on that.
Both theories are not supported by common sense. Let's look at Broder. What exactly was it in Broder's report that Ashley Benefield was so afraid of that she killed Douglas Benefield? Check your notes, but try to think back to Broder's testimony. I think your notes will reveal that Broder never had one thing adverse to say about Ashley Benefield. In fact, the only thing that Broder had to say was that after evaluating Ashley Benefield, he found that she had no violent tendencies. She was not prone to impetuous acts. That's it. Her only concern, according to Dr. Quintel, was that she was afraid if Doug found out what she had to say about him, that he would take it out on her or on the child. Okay, let's look at the theory then when it shifts to it being the domestic violence injunction that was scheduled for the 30th of September. What kind of reason exactly is that for her to kill Doug Benefield? If that was a reason, wouldn't she have done it before? There was already a domestic violence injunction the first time. It was denied. It was not only denied, but Judge Moreland ordered shared custody of the child. Why wouldn't she have killed him then? For 4 years, Ashley Benefield did what any law-abiding citizen can be expected to do. She filed complaint after complaint after complaint, calling Doug Benefield's behavior to the attention of the authorities with no result. Over and over again. No relief. So she kills him? Really, that's quite a leap, ladies and gentlemen. You need evidence to support such an inference. You know, you can't take innuendo and wrap it up in an inference and call it a fact. You got to have evidence that supports a theory. For example, you know, in the reasonable doubt instruction, I'm going to show you in a minute, but it says a reasonable doubt can arise from the evidence, from the lack of evidence, and from a conflict in the evidence. So what evidence would you need to show to support this theory that flies in the face of common sense? Well, how about somebody who comes in and testifies, yes, I heard Ashley, I overheard her say, you know what, I'd kill this SOB before I'd let him be alone with my child. Or how about this? How about downloading from Ashley's phone when she's sitting there in her most private moments, never expecting it to be revealed to the world, searching on the internet how to kill an abusive spouse. How about that? Instead, what you saw in her most private moments, 6 months before this happened, was her searching on the internet how to co-parent with an abusive spouse. Am I making this up? Check your notes. How to get along with an abusive spouse. In my opening statement, I told you two things. I said that at the conclusion of the case, those were the only two things that would be established beyond a reasonable doubt. The first one was that Doug Benefield was a very sick guy. I think there's no doubt of that. The second thing was that Ashley's action on that day, September 27th, 2020, was absolutely justified. Let's take a look briefly at Douglas Benefield's behavior. And I want you to keep in mind Bruce Ferris's testimony, who's the former cop who specialized in domestic violence, ran a domestic violence department, and then was so fascinated by it, went back to school to become a licensed mental health counselor. I thought he was a pretty persuasive witness. Doug Benefield shoots a gun into the ceiling of their kitchen to intimidate Ashley to stop speaking. Now, those are easy words for me to speak. And they fall on ears and you move on to the next thing. But I want you to try to imagine how it would feel.
Objection.
Sustained.
How would one feel sitting in their kitchen, having their husband pull out a gun and actually fire it into the ceiling of their kitchen? Can you imagine the trauma of such a statement? Do you think that that's something that you forget about after 6 months, after a year? I think that's something you remember for the rest of your life. You never forget it. Throwing a loaded gun at Ashley Benefield, threatening suicide, not only to Ashley, but to his former wife, Renee. You've got a copy of her text message that she wrote to Doug, kicking her on their honeymoon and threatening suicide. So this is twice now, not only with Ashley, but with his prior wife. Punching the dog so hard that he knocked the dog unconscious. Bruce Ferris on the wheel. Now, I'm not an expert on the wheel. I don't pretend to know it anywhere near as well as apparently Miss O'Donnell does. But I can tell you with certainty that it has a provision, and Bruce Ferris elaborated on the fact that abusers tend to hurt pets because they have no empathy and because, check your notes, they can control the victim because the victim loves the pets. So hurt the pets, you keep the victim in line. You get compliance, control, and compliance. That's what they seek. Threw the cat down the stairs. Put a tracker on her car. The neighbor catches him in the yard at night. It wasn't in the house across the street. You've got the schematic of the houses in the neighborhood. You see Mr. Sand's house is right next door, literally, to the left of Ashley's house. Ashley's house has got the red dot on it. Cursing, yelling, screaming, belittling. Text messages. I'm in a murderous mood. I want to rid the earth of them. Take them out. That was about two guys having a conversation while Ashley was on a cruise. Doug Benefield was so demented that just hearing in the background two men speaking while Ashley was on a cruise makes him say he wants to take them out, rid the earth of them. That puts him in a murderous mood. Of course, Ashley at the time at 24 thinks, well, gee, that's kind of flattering. I guess this guy really loves me. Oh, that was just a little tip of the hat to what was to come. The South Carolina injunction, he violated it. There's no way around that. How about driving from South Carolina to Florida so that you could follow Ashley in the car? I mean, if that's not determination, what is? If that's not fixation, what is? If that's not obsession, what is? And most chilling, I thought, was Mr. Vincicaro, the realtor, who, while the injunction is in effect from South Carolina, look at the email between Doug Benefield and Vince Vincicaro. I asked him, did you have any dealings with Douglas Benefield? Yes, I did. What was it? He was a customer looking to buy a home. Where was that home? It was the house immediately behind Ashley Benefield's house. This is sick, ladies and gentlemen. This is while the domestic violence injunction is in effect. Not only that, but then he says to Mr. Vincicaro, well, I have to first check with Ashley. Well, you know that's a lie. He can't check with Ashley because the injunction doesn't allow him to communicate with Ashley. So what's the basis for that conclusion that Doug was that disturbed? Well, how about Doug's own admissions? You have the text messages where he admits to Ashley, you know, I'm sorry, I apologize. And according to Miss O'Donnell, well, that should be the end of it. You apologized, it's over. Unfortunately, Bruce Ferris explained to you that that's the MO of an abuser. Oh, baby, I'm so sorry. Please forgive me. It'll never happen again. And it happens again. Time and time and time again. That's their pattern of behavior. And Bruce Ferris told you that. He explained that to you. Ashley Benefield got on the stand and told you about all of that. And I have a great discrepancy. I'm wondering if we were at the same trial between Miss O'Donnell's evaluation of Ashley's testimony and ours. But how about this, in addition, as a basis to establish how disturbed Doug was? How about the letter that Ashley Benefield leaves for Doug on November 17th?
Objection, not entered in evidence.
Sustained.
Judge, that was testified to by Ms. Benefield. I'm just speaking to the letter, not quoting from the letter itself.
Okay.
So she told you that she left him a letter. She told you what she put in that letter. That letter recounted some of the things that he did. Some of the things that you heard about in the trial, such as shooting the gun, punching the dog.
Objection, content of the letter.
So, how about that as a basis to support it? She described them as controlling and manipulative. You're putting me and my unborn child in danger by the way you drive. You drive crazy when you get angry. How about Dr. Quintel? He doesn't even have a dog in this fight. He's got absolutely no reason to shade his testimony one way or the other. What did he tell you that he concluded about Doug? That he was, quote, super controlling, unquote. That he was jealous. That he was intimidating. That he was a real alpha male. Dr. Quintel's description, not mine, ladies and gentlemen. And then we have Ashley. who's the victim of domestic violence. We have the history of the prior acts of domestic violence by Doug. According to Dr. Broder, the state's witness, and Bruce Ferris, our witness, victims of domestic violence look for appeasement. Dr. Broder, I even asked him, I think that word appeasement appears in your report about at least 4 times. They go along to get along. They walk on eggshells, always afraid that something they might say will set them off. And according to Bruce Ferris, what the abuser wants is compliance. That dynamic changes very significantly once a child is introduced into it. And why is that? Because the abused woman is going to look to protect her child. That's what mommies do. So she will put herself in danger in order to stand between the abuser and her child. Yet, Miss O'Donnell argues, well, when they first exchanged custody, as Stephanie Murphy said, Ashley looked happy and very content. Well, we know from Bruce Ferris that that's the compliance mode. That's what you do to protect your child. She knew how Doug was. He went off on her. The only thing worse than that would be him going off on Emerson, the child. You keep the beast at bay. Those were the words of Broder and of Bruce Ferris. Importantly, Bruce Ferris told you that victims of domestic violence appear to act happy. So you have these text messages in the week leading up to the shooting where they're saying nice things to one another with emojis and smiley faces. And you have the video of the restaurant where Ashley and her mother and Emerson are present. And Ashley appears to be acting happy, when in fact she's actually quite scared, according to Bruce Ferris. But you go along to get along. You might recall in the voir dire, I asked you about the presumption of innocence and how many of you had ever seen the cop car on the side of the road with somebody sitting in the back. And the first thing you thought to yourself was, gee, I wonder what did cause them to be in the back of the squad car. And I told you that the issue to be resolved in this case was going to be, was the force used justified? All of you pledged that if the state failed to prove their case beyond a reasonable doubt, your verdict would be not guilty. All of you took an oath that said, at the end of the case, if you were unsure, if you did not know what happened, if you did not have an abiding conviction of guilt, you'd vote not guilty. I want to show you the beyond a reasonable doubt instruction. Deputy, if I could have the easel, please. This is in your packet of instructions. You're not going to have to memorize it. I want to just go over it, though, for a moment. I think we can agree it's pretty important. remind you that the state has the obligation and the burden to prove the case, and overcome the evidence to the exclusion of and beyond a reasonable doubt. And here's how they define reasonable doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, goes back and forth, gee, I don't know, I'm not sure, then the charge is not proved beyond every reasonable doubt, and you must, not you can, ladies and gentlemen, not you may, you must find the defendant not guilty because the doubt is reasonable. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. Thank you, Deputy. Let's take a brief look at the facts rather than theories. Because once again, the prosecution could not have been more clear. Ashley killed Doug to prevent release of the Broder report. So where was the evidence to support that theory? You can't simply say it and make it so. Miss O'Donnell comes up, and the evidence that she presents to you to support that theory is that Ashley said, I'll take matters into my own hands. Ladies and gentlemen, Dr. Broder testified that Ashley made that statement on her way out of his waiting room. And I asked him specifically about it. Please check your notes. What was she referring to? And he said, going to the authorities in Maryland to seek relief from them because the system here had failed her, and she was very frustrated. Ms. O'Donnell also told you that Doug Benefield filed for sole custody of Ashley. Please check your notes. No one ever testified to that. There's absolutely no evidence in this case that such a thing was done or a statement was made. Other evidence in the case? Justin Warren, the lead homicide detective. State never even called him. Objections. We called him. What did he tell you? He told you that in his arrest warrant, he said it did not appear that Douglas Benefield was facing Ashley Benefield when shot. Now look, Dr. Vega came in here and testified that the shooting in the chest, the shot to the chest, was from front to back. Yet Miss O'Donnell comes up here and distorts that and tries to tell you that it wasn't from front to back. It was from side to side. Dr. Vega told you the trajectory of the chest shot was front to back, right to left. Now, not only did Dr. Vega tell you that, Michael Haig told you that, front to back. Dr. Liu told you that, front to back. There has never been any evidence introduced in this trial that the chest shot or the arm was anything other than front to back. Detective Warren told you he did not speak with the medical examiner before he submitted his arrest warrant. I showed him his report to refresh his recollection. Oh, yes, I did speak to the medical examiner. And finally, I asked Detective Warren about a supplemental report that he wrote where there's a section that provides for any bias that he was aware of that Ashley would have had against Doug. And the form was written none. And I asked, is that not where you would write in things like ill will, hate, or spite? Mike Haig, let's look at his testimony for a minute. I think you'll remember him. What he said, I thought, really presented it well, was in explaining what forensic meant. He said it's the juncture where law meets physical science. Okay? So he told you there were 4 shots. He gave you a 3-dimensional diagram, and it showed you the room and how the shooting took place and where the shots went. One shot, according to Michael Haig, went out the door and down the hallway and lodged in a book. He described it as a miss. One shot was in the wall. Told you it was a nice round hole in the wall. They put a trajectory rod in it. One shot was in Mr. Benefield's chest. It was lodged in his back. Dr. Vega removed it. And one shot was in the leg. The state's own witness, crime scene people, told you that the shot to the leg was on the floor in the room and that a piece of it had broken off. And Haig told you that as well. According to Miss O'Donnell, if you completely suspend the explanation that Dr. Liu gave you about the shot to the leg, if Douglas Benefield was running away, that's how you could get the shot in the leg. You might remember that the trajectory or the wound path to the leg was up. Ashley would have had to have been lying on the floor to shoot up so that the bullet would go in a calf. Dr. Liu explained to you exactly how that happened. We even had our summer law clerk, William Galvano, come here and demonstrate it.
It's a proper argument.
What else did Michael Haig tell you that was significant? He told you that they were moving. He said both Douglas Benefield and Ashley Benefield was moving. And he even showed you how it went from right to left in that 3-dimensional diagram, with the first shot out the door, the second shot in the wall, or one shot out the door, one shot in the wall, one in the chest and one in the leg. He showed you the 2 different cones. That would be consistent with what Ashley told you about trying to get more distance to move away from him. There was only one way to go in that room. She was already back to the back of the room, so the only way she could go was sideways, to her left. Finally, he also told you that Ashley's explanation was absolutely consistent with the physical evidence. Then we had Dr. Lou, Emma Lou, former medical examiner for Miami-Dade County, who has always testified for the state. Except here, she came in and testified for the defense. Why do you think that is? Dr. Lou told you that the abrasion to the arm, she believes, was from front to back, and she believed it was the shot that went out the door and down the hall. And the bullet would not have mushroomed or expanded, as you heard Michael Haig explain, that bullets are designed to be able to expand. Because the wound was so superficial, there would not have been enough tissue in the hollow point of the bullet to expand it. She also told you it would be consistent with Doug lunging at Ashley Benefield. And she showed you with rods how the abrasion to the arm would take place, as well as the shot to the chest. Now, here's something interesting that maybe everybody's forgotten. Miss O'Donnell did not address. Who was it that told us that Doug was skilled in martial arts and trained to take the weapon away? Why, that was his daughter, Eva. So here's Doug, who gets into his fighting martial arts position and lunges at her to grab the weapon, and Dr. Lou explains the abrasion shot. All four of these shots had no pattern at all. These are four random shots, no association whatsoever, indicative of somebody who's in an absolute panic firing a gun. What's more, as not only Mr. Sant told you, Mr. Haig told you, and as the state's own witness told you, if you don't hold the weapon properly and give it the pressure that it needs, it will result in a jam from one of the cartridges, just like what happened here. So I want you to please consider something. Before evaluating the defense case, you have to first determine whether or not the state failed to prove that the shooting was unjustified. That's your first order of business. Because if the state failed to prove their allegations beyond a reasonable doubt, it's over. You don't need to evaluate the case that the defense presented. We weren't obligated to present anything, but we did. And I think we can agree that if the state's case does not meet that threshold of beyond and to the exclusion of every reasonable doubt, your verdict must be not guilty. Ashley Benefield got on the stand and endured over 2 hours of cross-examination. It was our perception that the state never landed a blow. in over 2 hours. That's 2 hours in addition to the hour and a half that I had her up there on direct examination. In the world in which we live, it sounds strange to try to reduce an event like this to an explanation within an hour and a half. But this is the only form that we have to resolve things like that. So we did it. And Ashley got up there and she explained to you exactly what happened. And she did it well. And the state never touched her. Look at the crime scene photos that were taken, not at some modeling presentation, not at some outing. Look at the crime scene photos that were taken by Miss Dorvac. They're in evidence, and you see if you don't see swelling and redness on those photographs. So it's September 27th, 2020, the day of the homicide. Doug arrives at Ashley's house late that afternoon, and he's already simmering. He's on a slow boil, ladies and gentlemen. Why? Because he knows she's leaving. She's leaving. He's not going with her. He's going to live somewhere else. He knows that. This was his last hope for any kind of reconciliation. And Bruce Ferris told you that the most dangerous time for a domestic violence victim is when the abuser recognizes that she's leaving. So how does Doug respond? With threats and intimidation. He would not leave. Ashley tried to de-escalate it. She could see how he was starting to build. She wanted to avoid a confrontation. Gee, you know, Doug, we pretty much got everything done. Why don't we quit for the night and we can continue tomorrow? He ignored her. Instead, his hostility starts increasing. 2 body checks where he bumps her shoulder, passing her in the hall. And it's not a bump that's an accident. It's a bump to intimidate her. She told you she almost lost her balance. Then we have the cardboard box incident where he slams that into her. Once again, she tries to de-escalate it. She even apologizes to him. And I asked her, why in the world would you apologize when he was the one who hit you with the box? Well, shortly after that, Ashley's had enough. What does she do? She tries to leave. She tries to flee the house. He catches up to her, grabs her by the hand, whirls her around. His back is now at the front door, and he's got her blocked. Somehow, Ashley finds the inner strength to yell, "I'm done. You need to leave now. I'm done. You need to leave now." Please check your notes. That's going to be real important. Why? Because that revoked Doug's permission to be in Ashley's home on that afternoon. And here's what the instruction is going to tell you about that. It's in your packet. It's going to say the law and justifiable use of deadly force is as follows. If Ashley Benefield was in a dwelling in which she had a right to be, I think we can all agree this was her home. Doug did not live there. He was there by her permission on that day to help pack things. She had no duty to retreat and had the right to stand her ground and use force, including deadly force, if she reasonably believes such conduct was necessary to prevent A, imminent death or great bodily harm to herself, or B, the imminent commission of burglary, false imprisonment, or aggravated assault against herself. The elements of the forcible felony of burglary are: 1, Douglas Benefield had permission or consent to enter the dwelling or structure owned by or in possession of Ashley Benefield. 2, Douglas Benefield, after entering the structure, remained inside after permission to remain had been withdrawn, and with the intent to commit an offense other than burglary or trespass inside the structure. The offense was false imprisonment. Ashley tried to leave her home. Doug stopped her, spun her around, and held her trapped inside the house. Or B, attempt to commit a forcible felony. Forcible felony is aggravated assault. Through threats and intimidation, Doug committed the offense of aggravated assault. It's in your packet, read it. The important point is that once Ashley says, "I am done, you need to leave now," he becomes, in essence, a burglar by remaining in that house after she tells him to leave. Not my words, not my law, the law that Judge White has given you. The last witness that we saw was Amy Carlton. And you might wonder how Ms. Carlton fit into all of this. Well, actually, she played a very significant role. We called Amy Carlton to show that this was anything other than a staged event. If you accept Ms. O'Donnell's interpretation of this, it was a staged event. It was a setup. Ms. Carlton told you that she was out walking her dog with her husband. They heard a series of shots, and less than 30 seconds later, Ashley emerged from the house, hysterical, screaming, holding the gun, and ran right next door. If you're going to stage an event like this after the shooting, you're going to certainly check the scene to make sure it's going to support your version of the event. Because if it doesn't, you're on your way to prison. It's going to take you longer than less than 30 seconds to do that. The state has failed to prove anything here beyond a reasonable doubt. We prove self-defense beyond all doubt. But the burden is not ours. It's theirs. And they must prove it beyond and to the exclusion of every reasonable doubt, which, ladies and gentlemen, they just have not done. So, for the last several years, I've walked hand in hand with Ashley.
Objection.
I'm now going to surrender her fate to you. I've presented to you everything that I possibly could to show you the dynamics of what took place on that day and why they took place and what Ashley knew about Doug at the time they took place, to show you that her action in using deadly force was reasonable. The judge is going to tell you in your instructions you can take into account what she knew about the domestic history with Doug, The size differential between Doug and Ashley. Ladies and gentlemen, Ashley Benefield is not guilty of murder in the second degree. She's also not guilty of manslaughter. When you read the manslaughter instruction, it tells you that it is not manslaughter if the shooting was justifiable, if it was in self-defense. The manslaughter instruction tells you that as well. You all promised in voir dire that you would stick to your guns and not be intimidated by the majority or the other jurors. Manslaughter is a compromise. Ashley's not looking for a compromise. She's entitled to more than that. This is either second-degree murder or it's not. If you follow the oath that you took and you read the instructions, we're confident you will return a verdict of not guilty in this case. Thank you very much.
Thank you, Mr. Taylor. Rebuttal?
AB had enough. The defense just said that. AB had enough. She did have enough. On September 27th, 2020, she had enough. She took out a .45 caliber gun and shot Mr. Benefield 4 times. At Mr. Benefield 4 times. And why did she do that? Why had she had enough? I will do anything I have to do to keep my baby. Asshole. To a detective that she demanded arrest somebody in a courthouse because that will help her keep her baby. It is not surprising at all that Detective Dillon remembered that. That is an outrageous statement to say to a law enforcement officer. You will arrest him or I will make you. That's what she told a law enforcement officer. You think she'll tell a law enforcement officer that and she won't shoot Doug Benefield when she's had enough? No, she would and she did. Time is running out. Within a week of murdering Mr. Benefield, time is running out. She said that I will take matters into my own hands. She said that to a psychologist who was doing reports for the state, for the court. I will take matters into my own hands. And she did with 45. And let's talk about what we've heard. And it's my job to rebut the defense's argument. That's what I'm here for. And I think we can. And I do ask you to depend on your memory. But I want to set some groundworks. Number one, Miss O'Donnell and I are clearly part of an old boy network. No, this is not an old boy network. This is law. This is the law. And if those law enforcement officers did not find that they had the sufficient basis to arrest Mr. Benefield, then they wouldn't have. And that's why they did it. That is not an old boy network. That is how our country works. That is what the law is for. Otherwise, any woman could walk into any police station and say, my husband did X, Y, Z, and they're just going to arrest him? No. It requires evidence. It's the same reason that law enforcement took a long time between this murder and her arrest. They were investigating it. They were making sure they had everything they needed to have. And when they did, they effectuated an arrest. And the prosecution, you heard a lot. You heard Miss O'Donnell's name more than Ashley Benefield's name during that closing. It's not about Miss O'Donnell. It's not about Miss Friel. It's not about either of us. It's the state of Florida, and we have the burden. And we've overcome it. It's not a flawed prosecution. Our job is to prove to you beyond a reasonable doubt that the elements in this case occurred, that manslaughter occurred, which it did. Manslaughter is an intentional act that caused a death. She intentionally shot him, and he died. That's a manslaughter, no doubt about it. But that's not enough. She did it because she has ill will, hatred, spite, or evil intent. She had a depraved heart when she shot and killed Mr. Benefield so she could keep her baby. And does it matter if the report was coming out or if that injunction hearing was happening? No. Clearly, Miss Murphy and her client, who was murdered just a few days later, thought that Mr. Broder's report was coming out. Clearly, Faith Brown and Ashley Benefield thought or knew that they were having an injunction hearing on that day. The jig is up. She has wanted this man out of her life. She has wanted her baby to herself. And what is she doing? She's so scared of him, she has him doing her manual labor. You can come over. You can move my stuff. You can get the heavy stuff. You know what? Can you stop and buy me boxes? Can you stop and buy me tape? Do you want to go to the gardens? She told you that she couldn't dress a certain way. She was in a sports bra and shorts when he showed up. You didn't hear that he said a word. You didn't hear that he had insulted her in any way. She would have you believe all these things about Mr. Benefield. And mind you, Mr. Benefield is not on trial. Ashley Benefield's on trial. Ashley Benefield's the one that committed a criminal act on 9/27, 2020, when she murdered him. Don't be confused or distracted by emails and questions that showed you nothing. The question is, were the facts, did you learn whether or not she shot him and at the time she had a depraved heart? And there was no dishonesty by Stephanie Murphy. Don't be confused by that. I think they just had a different understanding of what was going to happen. There's certainly no dishonesty by Detective Gillum. Not remembering something or Detective Warren and being dishonest are two wholly different things. And nobody's expected to remember everything. The question for you, as Miss O'Donnell said, is whether or not it was reasonable and necessary for her to kill him, for her to shoot him that day when he's in a shorts and a t-shirt and flip-flops doing her work for her. And keep in mind, this ninja we've heard of, 5'9", 169, adult small t-shirt. Adult small t-shirt, size 30 waist. We know what that means. This is not a huge man. This is not a hulking beast of a man. And the state is not contending that he didn't make mistakes. He certainly did. One of the biggest being trying to maintain this relationship. It ended in his death. But was it reasonable? Never hit her. She said he never hit her. He did some outrageous things, but never hit her in any sort, way, shape, or form. In 3 years, they'd been apart. 3 years. Reasonable. Is it reasonable? She would have you believe that, and look at those text messages. Look at the text messages going into that week, that whole week. And look at, I would ask you to read the state's version because that is the complete conversation. Oh, I'm sorry. Those are the older text messages. When you look at the older text messages, this murderous intent, he's talking about her old boyfriends. She admitted that. And them choking her during sex. He's not talking about wanting to go out in the world and murder people. He's certainly not talking about her. It may not be what the average person thinks of a way to express your love, but apparently to Doug Benefield and to her, it was. Because she's like, I know, baby. Don't talk like that. She never checks him, right? She never says, oh, don't. She says, I think she says, it was just a fight. These men that were just talking, she says it's a fight. So don't be confused. Look at the evidence. But in the text messages leading up to that week, look at them. You have them. They're the ones Miss O'Donnell did that had the video of them playing a game at Panera where they're all yucking it up. I would dispute that she was afraid. I would dispute most of what Mr. Ferris said, but we'll come back to that. So she would have you believe that this man who has never struck her, who in 3 years she reports no abuse. 3 years. He's done nothing. She left him while pregnant, did not tell him that she birthed his baby, did not give that baby his name, and then files before he ever meets his child to terminate his parental rights. And no allegations that he insulted her, came to her house and hit her, did any of those things. shot any guns, had any guns, none of that. Right? So she did all those horrible things. If you want your baby, those are horrible. To Doug Benefield. She did all those things. Nothing happens. But this day, when she has been dictating for a week when he could come over, when he could help her, what they would do, she would have you believe that he got so enraged because she was done moving and she was tired that he hit her for the first time ever. And you get to decide if you believe her or not. I would submit to you that did not happen. There's no evidence of it, and you know it. You can see by those pictures. I don't care what Barbara Russell, who's clearly biased, right? Barbara Russell is a clearly biased witness. That's her. They have some kind of relationship that is clearly not professional. And she sat there and told you that she saw swelling. Keeping in mind, she saw her the night of. This is somebody who she had a professional relationship with and then moved in. The night of, that's who comes to her. This woman. She tells you that she has edema on her face. I don't know what edema is. I assume it's swelling and bruising. It's not there. You can see in those pictures. You're going to look at them. You can look at them till the cows come home. You won't see swelling. All those law enforcement officers who are trained to look for that, crime scene techs who went there for the sole purpose of finding injuries, and had some lawyer pointing out that her ear was red. Look at that picture. There's no redness. No redness. So he becomes so enraged that he hits her for the first time. She doesn't go down. She didn't say, I fell. This man is a trained fighter who's a ninja, and he hits her, and she doesn't go down. And she can't tell you if it was a slap or a punch. There's a big difference. There's a big difference. And if he punched her in the eye, her eye would look way different than it does. There's no swelling on the side from a punch. She'd have a black eye. Not a bruise. Not a swell. Nothing. So let's say it was a slap. Let's believe her. It was a slap. There's no redness, no swelling, no bruising, no scratching, no evidence in the photos. I mean, if somebody slaps somebody in the face, there's a red mark. Nothing. Within minutes. Stop. And even if you don't believe law enforcement, which I submit there's no reason to not believe them, Mr. Sand, that sweet old man who she brought this drama into his home, said, I didn't see any injuries. Wouldn't he be the one in the best position to see if she had been slapped in the face moments before? Certainly. He didn't see it because it wasn't there. It's an attempt to manipulate the system, which is exactly what she continues to do. And keep in mind, he's flipped out to the point of hitting her for the first time because she's tired and doesn't want to move anymore. That's what she told you. She didn't say she had tried to break up with him. She didn't say she had told him she didn't want to see him again. She didn't say any of those things. She told him she didn't want to live together when they were alone together. And it was fine. It was fine. So he gets so enraged and pops off and hits her or punches her in the face when she's tired, but not when she says she doesn't want to be with him. Is that reasonable? It is not. And trying to think of a way to say this nicely, but I would submit to you that everything that Dr. Quintal said about Doug Benefield was basically Dr. Quintal talking with Ashley Benefield's voice. She's a manipulator. She manipulated him the same way she tried to manipulate everyone else in the world. He said he met with them 9 times, and Ashley Benefield was present for 7 of them, and alone for 5 of them. So every bit of information he got, except for 2 sessions, comes through the voice of Ashley Benefield, the way she wants him to think things are. Right? He's very controlling. He's very alpha male, which is apparently a bad thing now. He's super controlling. He's jealous. Keeping in mind, she's the one that asked Doug Benefield, are you dating her now? When he's there with her lawyer. But Doug Benefield's the one that's super jealous. And what did he tell you? Other than he thought all those things he conceded that they were all based on what Ashley told him, not based on anything he observed. He conceded that, which I appreciate. But the weird thing was that he had this weird encounter where he thought that Doug didn't want to see the child. And what did he say? I saw him for a few minutes in my waiting room. I went into a session for an hour. And then I saw him for a few more minutes, and then we started their session. So what happened in that hour? Dr. Quintel doesn't know. For him to make any assumptions on what the relationship was between Doug Benefield and his child based on seeing him for those few minutes is not reasonable. There was no basis for that. And keep in mind, through all of that she's dictating when Doug can see that baby. We don't know if he knew she was out there. He's sitting in the lobby of a psychologist or a therapist's office. We don't know that he knew she was out here. There's so many assumptions that Dr. Quintel jumped to in order to say those things, and they're just not reasonable. Despite a court order, she's dictating when Doug sees that baby and how, and that you're supposed to believe that it was something weird about Doug that he didn't go out to the parking lot. He could have been in the parking lot for an hour for all Dr. Quintel knows. And you know, the one thing he did say that was interesting was Ashley said she was frustrated with the system, which sounds familiar. Time is running out. I'll take things into my own hands. I'll do anything I have to do. She's frustrated because she's trying and trying and trying to do these things based on things that are not happening or not true, and it's not going her way. She tried to terminate his parental rights. The judge said, he can see that baby. That 6-month-old that he's never seen. So what did she do? Well, I don't really want him to do that, so I'm going to dictate how he sees the baby. Now I'm going to be sweet again. Now I'm going to go back. I think the only person that was in a cycle was Ashley Benefield. I'm not going to talk to you for months, but when somebody says you can have my baby, now I'm your best friend again. That's not Doug Benefield. He acted the same way in those text messages as she told you he did for 3 years. No violence, no threats, no manipulation, no emotional abuse. And that brings me to Dr. Ferris. Mr. Ferris. Mr. Ferris has never seen a relationship he wouldn't say is a domestic violence relationship. He would not concede anything. On direct, Mr. Taylor was giving him hypotheticals that had 6 or 8 aspects to them. And he was able to just answer. Well, yeah, sure, that's domestic. Goes right on the wheel. I'm asking him simple questions, and everything he would not concede. The only one he conceded about was that if she was living on her own, he couldn't have been economically controlling her. But how do you not concede that one, right? That's common sense. Every other thing he refused to concede. And this is one thing I will agree with Mr. Taylor. We have different perceptions because I think Dr. Ferris was clearly biased based on his inability to answer my questions when he clearly could answer the defense questions. It's clear from what was happening in this relationship that Ashley Benefield was not a victim of domestic violence. Doug Benefield's the victim in this case, not Ashley Benefield. And that there was not this power and control wheel that Doug Benefield was on. And keep in mind, Mr. Ferris would have you believe that somebody could be violent and then never be not violent again. That's what he said. I said, are you telling me that once there's violence in someone, it can never be changed? Well, if that's true, why does he teach CBIP? He makes his money on CBIP, right? Certified Battered Intervention Program. If what he told me was true, he's wasting people's time because he doesn't believe anybody can get better. And we all know that's not true. People change. People learn. People realize what they've done. People apologize for what they've done. And while saying the words is not enough, 3 years of not being any way violent or threatening or abusive, That's an indication that Mr. Benefield was trying to change. He was trying to do anything he could to be with his wife and to be with his baby. And Mr. Taylor kept saying, the defense kept saying trauma. She was so traumatized by this gunshot in the ceiling. So she had a baby with him? She testified to you that that happened before they reversed, or around the same time they reversed his vasectomy. That's a big deal. That's a decision. That's not it. I think Mr. Taylor said, you found yourself pregnant. She didn't find herself pregnant. She planned to have a baby. They planned it together. They went through medical procedures to do it, and they did it. All the while, she's so traumatized. I would submit to you that is not the case. She wanted a baby, and she got one. But Doug was in the way. And as to that neighbor thing, it wasn't Mr. Sant. I don't know where that came from. There was no allegation it was ever Mr. Sant. It was some neighbor across the street. And Miss O'Donnell told you exactly what was in evidence. Somebody across the street saw some man in her backyard wearing a baseball cap. And clearly that must be Doug Benefield looking in Ashley Benefield's windows. That's ridiculous. That's a jump you cannot make. That man could have been looking for his dog. We have no idea. There's certainly no evidence he was looking at anybody's windows other than the defense counsel saying that. And even if he was, does not make it reasonable and necessary to shoot him. Is not a basis that would cause you to believe he's going to kill you. Going to kill you. Not a basis. I would submit to you he never was in that yard. He was never looking in the windows. But even if he was, a tracker, not a basis to believe he's going to kill you, if that even happened. The house, buying the house, I read that very differently. First of all, he wasn't trying to buy, he was trying to rent. And if you don't believe that they were talking while they had this mutual injunction, they were, I'm sure. Miss Benefield was lying to him, telling him they're going to move to Maryland and live in separate houses, but co-parent. And she was all the while planning with her attorney to have an injunction hearing in a matter of days. It's reasonable to believe that that mutual injunction was, I'm sure, Miss Benefield was speaking to him when it was convenient for her, when she could get something out of it. It only goes with the rest of it. This letter we've heard about that Miss Benefield testified all these things, it's another effort at manipulation. We don't know when she wrote that letter. We don't know what she put in it. We don't know if any of it was true. I can write a letter and tell you that I'm the Queen of England. It doesn't make it true. And just because I say I wrote it 3 years ago doesn't mean I did. I keep saying manipulation. And the reason is because this defendant attempted to manipulate the system. It didn't work. She attempted to manipulate the experts. She kind of did, right? Because what did we hear about Dr. Liu and Mr. Haig? They talked to the defendant. She told him what she says happened, right? I don't even think she told him the same story she told you based on what they said. But what do we know? So Mr. Haig, I will submit to you, I think Mr. Haig was great. I loved it. I thought he was very interesting. I thought he shed a lot of light on how this murder occurred, right? And I would submit to you that you should believe him over Dr. Liu when it comes to trajectory. He's an expert, no doubt about it. That's what he does all the time. Dr. Liu, the medical examiner. She seems like a well-qualified medical examiner who did testify mostly for the state because she worked for the state and is now testifying for the defense. And the defense asked you, why would she do that? She did that because she's getting paid. She got paid to be here. That's why she's here. That's why she's saying those things. And most of them were probably very accurate. So Mr. Haig tells you there's 4 shots. We know that, right? We had 4 casings. We have 4 projectiles. One is in Mr. Benefield's chest or back. And I think there was some misunderstanding of what Ms. O'Donnell was trying to show you. What she's trying to show you is that if it was from the front, because say I'm lunging, it would go in my chest and out the back. That's not what happened. It went front to back because it hit him here and came out here. Well, that's front to back. That's not front to back like it goes in my chest and comes out my back. That's front to back because it didn't end up here, right? Or she didn't shoot him in the back, it ended up in the other side of his back. It goes across his body, destroying his lungs, destroying his spinal cord, damaging his ribs. And what did Dr. Liu say? He dropped. He dropped. I think that's important. So Mr. Haig said there's one bullet, right? We got 4. One is in his chest. So we know where that one is. One's in the living room wall that Mr. Haig said he believed was going down and struck the tile and then bounced up and hit the wall. He knows better than me. Seems reasonable. 3 is in the wall, number 7. Perfectly round. Typical gunshot. Nothing in its path, because what did he say? If something was in its path, it would begin to tumble. It wouldn't be that perfect hole that we picture as a gunshot in a wall or a target or anything else. And then through his leg. So which bullet hit his arm? And I think Dr. Liu might have been correct when she had that young man laying on the floor. It probably went through his leg when he was on the floor. Because Ashley Benefield told you something. She said she's shooting down. We know that's not true, right? Because his chest is way up here. His chest isn't down here. But she told you that once I had stopped shooting when he fell. That's also, I think, untrue. Dr. Liu told you he would have dropped. So he's paralyzed, laying on the ground, and she continues to shoot at him. Otherwise, if you believe that she's moving from left to right to get away from him, he's dancing around dodging bullets. They would have you believe this is a very tight room. I don't know how tight it is, but you can see there's either a full or a queen size mattress in that room, and there's plenty of other room. This is not a broom closet. This is a full size bedroom. And what else do we know? Dr. Vega said that they had been at least 3 feet apart. 3 feet apart. Uncontroversial. Nobody said anything different. Except for our firearms guy, who talked very fast, but said he looked chemically at the shirt and found nothing. 6 to 7 feet. 6 to 7 feet. Even if we go 3 feet, you have to keep in mind that's from the end of the gun. She is pointing a gun at him. Here to Mr. Benefield is at least 3 feet, if not 6 to 7, when she hits him in the chest. At least 3 feet when she hits him on the leg, because Dr. Vega said there was no stippling on the leg. They're not in close combat. We keep hearing about this. They are not in close combat. They're a whole grown-sized man apart, 6 feet, from the end of her gun to his body. And we know that. That's from the science. That was uncontroverted. You heard nothing to question that. You can take that one to the bank. And I would submit to you that those 2 experts, Mr. Haig was the one you should be depending on, even though he's also spoke to Ms. Benefield, so clearly got one side of the story, or a made-up story. And that Dr. Liu is not the expert that Mr. Haig is on trajectory. So if you go in the back and you're curious about the trajectory, I would say you should depend on Dr. Vega's testimony about how the bullets entered the body and exited, which Dr. Liu did not contest. And as for the other bullets, you should depend on Mr. Haig, because he was clearly more suited to answer those questions. As to Detective Warren, poor Detective Warren, who gets called just to be impeached, said he had opinions. You know whose opinions don't matter in this case? detective warrants. Mine don't matter. Miss O'Donnell's don't matter. Defense state attorneys don't matter. It's your opinions that matter. It's when you go in the back and you listen to the facts and evidence in this case, and you decide if we've proven our case. If Detective Warren, at the time in which he made his decisions, thought that he was shot in the back, that's not wholly unreasonable. He may have been mistaken. It doesn't make his opinion invalid, but what it does, it's not relevant to your decision making because you're depending on the facts and you have the accurate facts.
We have 10 minutes.
Thank you, Judge. I appreciate that. And that whole bias business, Detective Warren explained what that is. That's sexual bias or racial bias. This wasn't a hate crime. This wasn't a crime because somebody hates somebody else because of their sexual orientation. That's not what this is. That's not a place to put ill will, hatred, spite, or evil intent. Ill will, hate, spite, or evil intent is not bias. It's an element of second-degree murder. It's a depraved heart. And that's what Ashley Benefield had when she murdered Doug Benefield. A few more things, and then I want to talk to you lastly about the reasonable doubt. As to Dr. Broder, I think you should take some of what Dr. Broder said to heart. His concern, her concern, was not that Doug was going to fly off at the handle. She said she was concerned she would make him look bad in front of Dr. Broder. I pretended that I'm moving to Maryland and going to co-parent because I don't want to make him look bad. This man that I would have you believe was a abusive, horrible man. They have defamed him up and down. No, she didn't say that. She didn't say, I was afraid that Doug would freak out on me. I was afraid he'd do this. No, she said, I didn't want to make him look bad. She's manipulating Dr. Broder, right? She's manipulating Doug for sure. She can't say in front of Doug, I'm not moving to Maryland. Because then who's going to move her boxes? Right? I can't say in front of Doug, I'm not moving to Maryland with you. Because then maybe he won't drop his divorce case. Then maybe he'll try to take my baby. Right? She can't let him know that. She can't let him know that till he's packed her up, ready to go. It's manipulation. And that's what she does. That's what she's done. The evidence has shown it to you. And it doesn't matter if it was the report or the injunction. She knew the jig is up. He might seek more control. It probably just went in there. But Stephanie Murphy told you that when they went, that she was trying to get an injunction and it was denied. And he was trying to get custody, visitation, see his baby for the first time. She said something I thought was very telling. The judge gave Doug sole medical control or primary medical control over the baby. Right? So now he's already got some control. She can't do anything without him on the medical stuff, right? Of course she's worried. Of course, because she wants that baby and she'll do whatever she can do to keep it. Her. And I wouldn't put anything in the fact that she didn't confess on her phone, that she didn't tell somebody that that she had shot him one way or the other. She didn't even tell her mama. Her mother would have you believe that in all these years, she's never said something to you. You think she's going to put it on her phone? No, she's smarter than that. If that's true, she's certainly not going to put it on her phone. And just because you search up how to co-parent with an abuser doesn't mean that person's an abuser. I would submit to you that Ashley Benefield is very smart. She's been working the system or trying for years. And if I say, oh, I'm trying to co-parent with an abuser, that looks good for me. He's an abuser. He shouldn't have my baby. He shouldn't have medical control. He certainly shouldn't have custody, partial custody, or anything else. Just because she said it doesn't mean it's true. And that's because, as I said, she tried to manipulate the system in South Carolina. It ended up being mutual. She tried to manipulate the system in Florida. She got turned down. She tried to terminate his parental rights. The judge gave him custody. She tried to manipulate the experts, as I already talked, and I think in some cases she did. And she's trying to manipulate you. You can decide what you think about her testimony. She's a witness like any other. But I would submit to you that that was all manipulation. There were no tears. You use your common sense. If you cry and have to take breaks and you're racking, then you're going to have a swollen face. Your eyes are going to be puffy. You're going to have snot. I don't know what other word to use. She didn't even get a tissue until I can't remember who, either the judge or the defense attorney told her, hey, there's tissues. Oh, yeah, I should have a tissue. She'd been crying for 15 minutes. Didn't need a tissue. That's manipulation. That's her efforts to manipulate you and make you believe that she was a victim. She is not the victim. Douglas Benefield was the victim in this case. And reasonable doubt, I would ask you to read your instructions because that board they put up was an incomplete instruction. It left out parts. And the part is that proof beyond a reasonable doubt does not mean proof beyond all doubt. You don't have to get back there and have no doubt. You have to get back there and decide, did she shoot and kill him with a depraved heart? And I would submit to you she did. And then you have to decide, was she justified in using self-defense? Was it reasonable and necessary based on what happened in that house that she shoot and kill him on September 27th, 2020? It's not a mere possible doubt, a speculative, imaginary, or forced doubt. That's not what we're talking about. We're talking about a reasonable doubt. And the state would submit to you that we have proven beyond a reasonable doubt that Doug Benefield is dead. The death was caused by a criminal act of this defendant, Ashley Benefield, and there was an unlawful killing by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. And it was not justified. It was not based on self-defense. It was not reasonable and necessary to stand 6 to 7 feet away from that man and shoot at him 4 times. And I would ask that you come back and find this defendant guilty of murder in the 2nd degree with a firearm. Thank you. Thank you, Judge.
All right, can you go back to your instructions? And if you remember, we left off at 3.10. And we're going to ask when you find that, if you just look up at me and I'll know we're all on the same page. All right, got it? These are some general rules that apply to your discussions. You must follow these rules in order to return a lawful verdict. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits in evidence and these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case at all. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything that I may have said or done that made you think that I preferred one verdict over another. You may find the defendant guilty as charged or guilty of such lesser included crime as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to the crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. And of course, I explained it earlier. In just a few moments, you will be taken to the jury room by the court deputy. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the courtroom, in the jury room. If a juror goes to the restroom, the deliberations should stop until that juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication such as email or any other means. Do not contact anyone to assist you during deliberations. These communications rules must apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the court deputy. Many of you have cell phones, tablets, laptops, and other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices on your seats where they will be guarded by the court deputy while you deliberate. Let me break the script to say also, these jury instructions haven't been updated in a while. And if you have a watch, a smartwatch that can communicate with the internet or make calls or send and receive texts separate and apart from your phone, that also needs to go in the Tupperware container that the deputy is holding up. All your electronic devices will be there, but you can't have anything in there that will communicate outside the jury room. If you need to communicate with me, send a note to the court deputy. If you have voted, do not disclose the actual vote in the note. If you have questions, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here at open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate. I'm going to stop there also. When you go back, I think there was a few electronic items or things to view on a computer or on a DVD player. There's going to be what we call the tech cart that will be in the jury room with you. There's instructions on top of that about how to work the different devices and everything. If you have any problems at all, send a note to the court deputy and I'll make arrangements for our IT department to come down and get going whatever you need to get going. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate the rules we all share. Now, as you gather up your notes and your other items, as I said, you're able to take these jury instructions, your notes, back in the jury room. Before I let you do that, though, I do want to let you know, all of you know, that in almost every case, we select the jury as well as alternate jurors in case one of the main jurors is not able to fulfill their duties. Especially as we've come out of COVID, it is not uncommon. I'd say 20 to 30% of the cases, we have somebody get sick or something happens, and an alternate juror has to step in and serve on the main jury. Alternate jurors are incredibly important, as it does happen every so often that for various reasons, jurors are not able to complete their service and an alternate must be seated on the jury. In this case, jurors 38, 42, and 43 have served as alternate jurors. As such, I am not able to allow you to retire to deliberate with the rest of the jury. Do the three of you have personal effects in the jury room? You have stuff in there. Here's how this is going to work. You're going to leave your notes here. I'm going to ask you to go back in the jury room with everybody. The deputy is going to take you back. I need you to gather up all your personal effects and then come back out here to the jury, to the courtroom, so I can give you your final instructions before we let you go. But I'll need you to come back out. The other remaining 6 of you, when you go back, let those 3 jurors or alternate jurors get their things. You may not begin your deliberations until the deputy steps out, has received your electronic devices, has stepped out, and that door has closed. Then you may begin your deliberations. All right, do we have the exhibits? You got the exhibits, Deputy. Can I give you the verdict form? All right, so all of you may step out at this point, and then I'll need the 3 alternates to come right back out, please. For the other 6, you may now retire to consider your verdict.
So, guys, what do you think? I think maybe tomorrow. I think we're looking at maybe tomorrow. But, I mean, I've been wrong before many times. It's really hard to know what they're thinking behind those doors. But my thoughts are probably tomorrow. What about you guys? Well, it sounds like a guilty to me, personally. How about you? What are you thinking? Yeah, and again, it can be you too. Yeah. But again, I mean, you don't know what they're thinking behind those doors. And it's like, oh, are we seeing the same thing? The veterans. Yeah, I mean, it's a hard call. It's a hard call. But I'm going to keep my eyes peeled. And as soon as we hear something, I will do my best to get it out to you right away. There's quite a few different things going on right now. We've got Nicholas Mew tomorrow morning, and he's being sentenced. And if you don't remember who he is, he's the one that attacked all those kids while they were floating down the river. So he gets sentenced tomorrow morning. And I really wanted update on the Southport nabbings in the UK. Another little girl has passed, so that's 3. And I think the total amount that he ended up attacking was 11 in total, if I remember correctly. It's just the saddest thing. So I'll either do that tonight or I'll do that in the morning after Nicholas Mew. So guys, let's hope for a fast verdict. And if you have not subscribed, please do. And hit that subscribe, like, share it out. I'd appreciate it. So, guys, with that, I will see you guys soon in the next one. Bye.